Kushi, let me know. Okay. So Ravi, we are recording. We have all our guests in, and it's time. Let's get started. So thank you very much for joining us today, all of you, on a Saturday afternoon. This session has been a little long overdue. We constantly keep talking to all our clients about estate planning, and you should do it. And usually there is, we struggle with getting that done. There are some questions that remain unanswered, or there is a little inertia to get started. So I thought it'll make a lot of sense for us to get Ravi and Shailendra, who are experts in this field. I will introduce them and get them to answer questions that we have. Tell us why it's not so difficult, why we should get it done, what happens if you don't, and all of those lot of questions that we have. Right. So let me quickly introduce Ravi and Shailendra. They've been well wishers for us. They've been supportive of all the activities that we've been doing. Shailendra and Ravi run this company called Plan My Estate. Shailendra is widely recognized as one of India's foremost advisors in estate planning, succession strategy, and family governance. They work with corporate men, with family businesses who are transitioning, and they're experts in succession there as well. With over 2 decades of experience in management, fiduciary services, and legacy planning, he helps families and business owners. He has also been recognized as Time's leading icons for the year 2021 for excellence in estate and succession planning, and he regularly writes and speaks in various publications. Ravi, who's also been a friend and well-wisher, he's a co-founder at Plan My Estate. He's a seasoned chartered accountant with over 35 years of experience. So it's a lawyer, chartered accountant. So tax matters, legal matters, they come together very beautifully. He's had a professional career both in India and abroad in senior roles in various corporates. But now he's exclusively focused on estate planning and succession advisory and intergenerational wealth structuring. So Ravi brings a very powerful blend of technical precision, regulatory awareness, and deep empathy to his work. And he helps families navigate not just the financial part, but also the interpersonal and the legal dimensions of long-term estate planning. So the two of them veterans in the industry, and we're really privileged to have them as our partners to answer queries of our clients. Some of our clients have also used their services to get their wills written and their estate plan done. So thank you very much, Ravi and Shailendra, for joining us today. We have we have quite a bit of people here, about 35 of our guests and clients who've joined in today. So Ravi, very quickly, are we expecting Shailendra to join now, or do you want to take the questions yourself?
No, I think Shalendra's client meeting is going on. I think he might
Okay.
join in about 10 minutes or so as soon as he is
No
done with.
problem. So, sure. So, we will pitch into his wisdom when he comes along. But meanwhile, I'm sure you can take these questions as well. So, Ravi, as we were saying, one thing is very commonly that we hear is that estate planning is a lawyer's job, and there are so many lawyers out there who can do this, or it's actually a sample will. Just take a sample will and change the name and details and everything. Or there are also a lot of online portals that write these wills, right? But however, we have been constantly telling our clients, please go to a proper lawyer, because there are a lot of nuances in getting that will done. So Ravi, I wanted to check with you, I mean, how when what seems like a very simple document, the will document, what all goes behind it? Why is it that we need an expert planner here to do this for us?
Yeah, thanks for this introduction. Good afternoon, everybody. I think first let me just explain the concept of estate planning in India. And I think this is a very old concept, well established overseas, and now it's coming into India. Estate planning firms are a little different from typical law firms, right? Estate planning typically involves a lot of cross-domain expertise because you have various aspects coming into play. Law itself is a huge field, right? So you'll have the personal law, you'll have the Contract Act, you'll have the Transfer of Property Act, you have the Sharia law for Muslims. Now, there are many laws which have an interplay when it comes to estate planning, even for that matter, the Income Tax Act, the income tax laws come into picture. The corporate laws come in if there is any kind of business. It could be a LLP, it could be a corporate business, it could be a partnership business. And when you are uh, transmitting your business interest to your children, you need to also keep in mind the corporate laws, the Partnership Act. So it's a mix of a number of other can say laws as well as other areas of expertise. It involves occasionally also accounting work. There is a lot of administration work involved, especially when a person passes away and you get a court order, which could be a probate, it could be a succession certificate, it could be a letter of administration. We can get into these things later, what each means. But that's only a starting of the estate transmission. Just with a court order, you cannot say that the estate transmission has been done. So you take the court order and you go to a bank, let's say an HDFC bank, and you say, I'm the beneficiary, my parents passed away, here is the court order, transfer the demat account to me, or the savings account, or the locker for that matter. uh, there is the whole bunch of forms, documents that they will give you and say, you please fill up all this and submit it to us. So that will involve indemnities, affidavits, no objections. So there is a lot of running around that is involved. So we also have a team for all of that for our clients. So we do a lot of the admin work typically after a person has passed away. So our focus as estate planners is we give a complete solution and we see that it's delivered. The solution is delivered. So we just don't, sit and draft any document or get a court order and give it to the client and say now you run with it, right? So even if you have to transfer your flat to a society, the membership. The society will say, okay, here you have the court order. Now you get, these are the 10 forms you need to fill up and you need to give it to us. As we speak right now, I'm handling a case where there's a release deed. We opted, got the release deed done. The society is now saying you have to put out an ad in the papers. So we draft the ad for the society, then we put it in the newspapers. So we handle the entire end-to-end process for our clients. So end of it, the day, we see that the membership also is transferred to the beneficiaries. So there's a whole lot of things that we do for our clients, which is something normally a lawyer will not do. It's
Mm,
outside their scope and also sometimes areas of expertise or interest because lawyers are more happy drafting documents and going to the registration office or going to the courts because that's where the money is.
mm, mm,
So
mm.
we do.
So this is in alignment with the way we also work, right? Because we just don't stop with just doing the plan or giving the advice. We want to ensure that it is, taken to its logical end, and that I think that takes a lot of pain away. Though you call yourself planners, it's like a beautiful orchestration of multiple things, taxes and legal and all the admin work. I think the admin work is the most painful bit, right? Getting all these documents done. So is will the main focus in an estate plan, Ravi? Or do clients also need anything else apart from a will? While we will try and understand better the whole nuance of writing a will.
Yeah, will is the most popular, the most widely used tool in estate plan, right?
Okay.
Everybody typically will start off with a will. Uh,
Mm,
uh, Having said that, it's not always that you have to have a will. Perhaps you don't have a immobile estate, then you have joint accounts, you got nominations. Uh,
mm,
then you might say, why do I need a will? Right.
mm,
So I agree at some, and if the family is very simple and the nominee or the joint holder is going to get everything after the person passes away and doesn't
mm,
have any immovable assets, then
mm,
yes, you don't need, perhaps you may live without a will. You don't may not need a will. You
mm,
can say, okay, I can uh, go afford not to have a will. But
mm,
I think most people typically have a house, uh,
mm,
especially in the metros where they stay. So, moment a house immobile property comes in, you need to have a will because it has to go through a probate. If you don't have a will, then you go into a letter of administration. That
mm,
means the person has died without a will. And
mm,
what it means is then somebody in the family has to move the petition with the court saying, appoint me as the distributor of the estate of my whoever parents or sibling or whatever. So that there's a whole process for that. So then the question is, what is the difference between a will and a letter of administration? In either case, you have to go to the court. People do ask us that. Why should I write a will? Anyway, it's going to go through the court process, whether I have a will or not a will. But the thing is, if you don't have a will and you go to the court, let's say the spouse goes to the court saying, I want,
ஃபோன் பண்ணா
my
எடுக்க
husband has
மாட்டீங்க.
passed away and I need a letter of administration. There are challenges there if there's no will. So let's say which were we dealt with a
5 மணிக்குள்ள
recent
ஏறினா
case.
5 மணி நேரமா?
Just 1 minute.
சரி
Sudhir, can you mute yourself, please?
சரி 10 மணிக்கு எப்படி போனோம் வீட்டுக்கு?
வீட்டுக்கு வந்து இது
Sorry. Kushi, can you please mute him?
ரெட் டாக்ஸியா?
டாக்ஸில வில்பம்.
Yes, wait.
வில்வம்னு இருக்கா? லோக்கல் டாக்ஸி இருக்கா?
ஆமா.
சரி இப்ப நாளைக்கு கிளம்பணுமா?
Done.
Okay.
Okay, no problem. So if you know we handled a case where the lady in US lost her husband all of a sudden due to some liver problem. And obviously the husband didn't have a will, he was just about 40 plus.
Okay.
And what happens is you move the letter of administration, and then you realize that the two children also have become beneficiaries of the property of the house that he had in Panvel. And we get the court order, but unfortunately now she cannot sell the house.
Mm-hmm.
You need a court order when you want to sell the house, the share of the property of the minor child. Now, therefore, after the letter of administration, you also need to again go back to the court for permission to sell the minor's stake in the property. Therefore, there are additional costs involved, which could have been avoided if there was a will. So, always it's good to have a will, however simple your family may be,
Okay.
and estate. So, yes, that's the most popular concept people use as a will. But it doesn't end with that. There are a lot of different strategies we use depending on the situation of the family. So we at times use a gift deed. If we say that, okay, you don't want to go through the whole probate process, delay the transmission by 8 months, 10 months. You have financial assets, which you have nominees, joint holders, everything else is sorted. Then we say gift the property to your beneficiary, whoever it is. And then you're sorted. Perhaps you don't need to go through a probate. Your family doesn't need to go through a probate after you've passed away because the bank wants everything move away. So we use a combination
Okay.
tools.
So do you also look at the tax efficiency when we suggest something like this? Because as I understand, a gift will involve, registration and all that, but inheritance will not, right?
Yeah, so we keep that cost we do a cost benefit analysis for our clients. So if we do a gift, there is 1% metro cess that comes in right today in Maharashtra. I'm not talking more Maharashtra. Delhi has its own rules, but normally across all states for gifts there is a stamp duty of some kind, which will be typically a percentage of the estate. So you have 1%. So then the question is, if I don't do a gift and I do it through a will, do I save on the stamp duty? The answer is yes. But in this case, as I told you, the probate itself will cost you more than 2 lakhs as of today. Okay. If the person is going to pass away after 10 years, the court fees may be different. It may be higher, the lawyer inflation costs. So right now we are doing this for another client in Chembur only. So his son is in Canada. He's got cancer, the client. So he's saying, why do I do through my will to my son? I would like to gift it now itself. The stamp duty 1% of 3.5, 4 crores. He says we are willing to pay now because anyway the probate is going to cost us 2.5, maybe more whenever I pass away. So he's saying let's do a gift and avoid the probate, and so that all my other financial assets can move quickly to my beneficiaries. So we do that cost benefit analysis. And we also go beyond that. I mean, we know the son is in Canada, he's a Canadian citizen. Okay, if we gift the house, then if the house is on rent, given on rent. So the rent income goes to the son. Now he's an NRI. So if he's an NRI, the NRI tax comes in, he has to pay tax in India and as well as in Canada. So, of course, subject to double tax agreement. So then the question is, can I do a gift in such a way that the rent goes to the father as long as he's alive, and then to the mother, and then last to the son? So if I can build that into the gift deed. So, but there are challenges there because the sub registrar's office will say, I've never seen a gift deed where part of the interest in the property remains with the father, and only the title goes to the son, and they create problems. So we have to go explain to them, tell them what this whole thing is all about. So we take care of a lot of tax efficiencies also in a structure. So it's not that he says I want to do a gift and I just do the gift for him. I,
Okay.
we go through the whole cost benefit analysis across
Okay.
the income tax, everything for the son also. So, and the father is saying, as long as I'm alive, I would like to enjoy the rent because that's my only source of income today.
Mm.
So that I should not lose. So the son should ensure that the rent comes to me. So we see whether we can build those conditions into the gift deed. So
Okay.
that requires a lot of income tax knowledge.
Mm.
You then go to the registrar's office, explain. And each registrar has his own view. So we
Mm.
go across offices and see which registrar will agree to something like this, what is their view, and then try to build a document which is acceptable. So
Okay.
the whole thing.
Interesting. Okay, so you're saying there is a legal angle to it, and then there's a tax angle to it, and then sub registrars accept, don't accept. Then there's an admin angle to it, which probably not any lawyer who's
Correct.
will be able to handle it. And amongst lawyers also there are specializations, right? So an estate planner knows probably a little more nuanced way of doing things.
Yeah, so that's an important point because see, lawyers, like doctors, today every doctor has a specialization, and when Mr. X is a cardiologist, the other is a nephrologist, the third is a diabetologist. If you have a diabetes problem, you don't go to a cardiologist because his board very clearly says he's a cardiologist.
Mm.
Whereas an advocate today has got a board just saying advocate. Now, if you go to a real estate advocate and talk about a will, he will never say, I don't know the subject. He'll say, yes, I will draft a will. And the first thing they will do is, many of them, is just try to take a copy from some of their friends or samples and, then do one will and give it to you. They don't know the real practical issues that will come up tomorrow when the will goes for execution after the person has passed away. So not all advocates are well equipped to handle estate planning documents. So that is something that we know. We know which lawyer is good for, because sometimes our estate planning solutions have got a real estate angle to it. It has a will drafting angle to it. It may have a Indian Contract Act angle to it. There's a corporate law angle involved if there's a business asset to it. So we have different lawyers. We know who should be involved in what part of the estate plan.
Okay.
And we know how the fees should be structured. We try to ensure that they don't overcharge. So that's how we work with them. And they're all dedicated. We have a team of about 5 lawyers with the specializations. So we will use them depending on the case of the complexity of the case and what kind of specialized inputs are required and which lawyer is competent to give a view on that.
Okay. So in couple of things that keep coming to us often is, when should somebody make the will? While we do try to tell them, it is as of today, you must have already had a will. Is there any guideline, or is there anything that you can share about when someone should actually make a will?
Yeah, so we used to have this kind of a small like a game, not a game, I would say, I don't know what's the right word to use, when we used to do these workshops for a lot of our clients, saying, okay, we tell clients to write your date of birth on a piece of paper, right? So everybody writes. And then we say, now you write your date of death, right?
Okay.
And that's when then look at each other. So we say, exactly. So, death never comes by appointment, right? It's unexpected. So typically anybody who's married, has wife, has some assets, and if they have a child, then definitely they should write a will. They should not wait that till I become old. I need to wait for a will. We would always say, if you're married, you have child, you got assets, write your will. So that's our view. So write a basic will, and the wills can be changed as many times as you want. So once you have a good template in place, you can always update it yourself also as the situation changes. If you go through a divorce nowadays, we come across so many clients who go through divorce for whatever reason. So they come to us for advice relating to divorce also. Incidentally, for us, estate planning is not just about hard assets. We also advise on the soft issues of the family. Sometimes people come to us for advice on divorce, so we have a divorce lawyer with us, and how to ring fence the assets if they sense that
We're losing Ravi a bit. Kushi?
Yes, I'll get in touch with him.
Okay. I'm seeing some questions as well here.
The-
Ravi, we lost you. The last few minutes will be okay.
Now,
We just lost you in probably the last 30, 40
yeah.
seconds.
Okay, can you hear or?
And now I can hear you, yes.
Yeah, so what I was saying is, so our estate planning is not just about hard assets. It's also
Okay.
about softer issues around the family.
Okay.
Whether if there's a member of the family going through a marital discord or a child custody, guardianship, supporting all of that. So because the clients, uh, have, or rather we have our clients' confidence, I would say. They kind of come to us for all advice around these matters.
Okay.
We bring the right lawyer in to advise them. And we have done that for one of our clients for advising his nephew on divorce. So
There is a very, very basic question that Shubha has asked saying, what if there's just nomination? I know we've addressed this many times, but it makes sense to hear from your side. If I just have all my assets nominated properly, do I still need to get a will done?
yeah, see, nomination is a very basic step in case of movable assets. Because if there's no will and the person passes away, at least the nominee can go and immediately get the bank accounts, the mutual funds, demats, everything transferred to them, and then they can at least ensure that it doesn't get frozen in the account of the deceased. Otherwise, let's say you got shares in a demat and there is no nomination. And the other mistake people make is husband, wife, they make nominees. We had a client 2 years ago where both of them passed away within a gap of 1 month because of, the husband passed away first and out of shock, the wife also passed away soon. They were nominees to each other. The children were never made nominees. Of course, the children were also adults. But because of that, the children had to go through a hard time because there was the nominee also had passed away. So in which case, all the contents in the locker, which had some cash, jewelry, everything was stuck because NGFC Bank said we will not release it till you get a court order. So a nomination is good. Better to have maybe two or nominations. I guess it's allowed now. I think up to 3 or 4 or whatever. So nomination is a very basic step. We advise everybody to see that there is nomination done, but at the same time, it's well synchronized with the beneficiaries in a way, so that there's no conflict. Because if there are multiple beneficiaries and you have only one nominee, then we have to. There's always a risk that the nominee may walk out with all the assets and say other beneficiaries left high and dry, then the person has to go to the court and all that. So there's a long process. But to an extent, you can ensure that it's well aligned. You can, nominee is necessary.
Okay.
Even for societies, people put, nominees, but people have to be informed that nominees in the society is only nominee as far as the membership of the society is concerned. Legal title of the property doesn't move to the nominee in the
Okay.
government records, right? There is a separate process for it. So there you need a probate or you need a letter of administration. You have to go to the registrar's office. In the beneficiaries have to present the right documents, get their name mutated, and then present those documents to the society. Right? Most people think that in my share certificate, if my name is been as put as a nominee, I'm the legal owner of the property. And when you go to sell the property, and the buyer looks at the title, he does a title search, he'll realize that the property still rests with the parent and not has not moved on. So then you go into the whole process. The buyer will walk away and say, now go to the court and get a court order and change your title.
Yeah.
That means loss of 1 year. So all these things have to be done. So nominee, this is what people need to be aware of.
Okay, understood. Shubha, I hope that answers your questions. Shailendra has joined us too, so thank you very much for joining, Shailendra. I'm just making a follow-up question. Ravi mentioned that if you're married and you have children and you have assets, you must write a will. But if someone is single, don't they have to write a will?
Yeah, thanks, Guna. Yeah, even if you're single and you don't have immediate family, so you should still write your will primarily because what happens to your asset after you is important. In fact, in this kind of situation, it is that much more important to write a will.
Okay.
There is no immediate first class one legal heir. Okay.
Mm,
Otherwise, the law says, okay, class one legal heir is so and so. In class two legal heir, there could be multiple people. Okay, there could be siblings and etc. Then there is a more chances of dispute.
mm,
Okay. So that there you need to very clearly say that after me, so and so person. I had this case where just before COVID, I met this gentleman who was very well-known Feng Shui expert, very celebrated person. And his wife left him. I mean, he was divorced. He had a son from the marriage,
mm,
but the neighbor was taking care of them for last 10 odd years.
mhm.
And when he was unwell, so when I met him, he wanted to give everything to the neighbor and neighbor's son, to the neighbor's family. So the
Okay.
whole discussion had happened, and then I was following up. COVID happened. And then I heard that he passed away through the advisor who introduced me. Then I realized that all that he wanted to do would never happen because somewhere from the background, the son came who never met him for 10 years. He came to the house and he claimed. And he has had a claim because even after a divorce, while the wife doesn't get anything, the
Mm,
son from the previous marriage will have a claim on the assets
of course.
because obviously he's a
Legal.
biological son. He's a biological son. So
Mhm,
in
mm,
such situations, it is that much more important to write a will. Even if you want to give for charity, you should tell who gets
mm,
it.
mm,
Yeah.
mm. Okay. Thank you very much, Shalindra. That's very revealing. So a couple of questions that have come in the chat box also, Ravi and Shalindra, one of you can take it. If Ravi did mention that it's okay if you want to change the will, you can change the will. Is it necessary to register a will? And if we want to change a will, there is this pain of re-registering the will every single time, right? So, is it advisable to write a will and register it? Because one of our clients did mention that because his father had a registered will, it was a very smooth transmission for him. But the whole process of registration, uska cost, and then having to make changes. What would you advise?
We strongly advise our clients to register a will, while registration of the will is optional in India. Okay, as per the Indian Registration Act, will is one of the document. Even if you don't register, it is absolutely valid,
Mm-hmm.
provided you have signed within date and
Mm-hmm.
there are two valid witnesses. Okay, so registration is optional here. But why you need to register? The important point is that when a person registers, okay, he along with his witnesses goes to the registration office,
Mm-hmm.
does the biometric. Okay, all the records are now kept. There is a digital proof and a actual proof in the registration office that the witnesses were there, you were there. In some cases, when the testator is very old, registration guy, I mean officer asks, आपको पता है आपने बिल किया है ये है. I've seen that actually happening. So they actually verify. And when you go for registration, now the latest rule is that you need to have a doctor's certificate also saying that the person was of sound state of mind. Okay. So there are
Any
multiple,
age, is it?
sorry, any
Is
age,
it any age? Acha. Okay.
any age. So they will insist, otherwise they will not register. Okay. So what you're doing is you are creating multiple layers of protection in case your will gets contested. Okay.
Mm-hmm. Mm-hmm.
So from that perspective, we always advise that please go and register your will because for all these reasons which I just said.
Mm-hmm.
Now, one more important point is when you register a will, okay, then a copy of the your will is also at the registration office.
Mm-hmm.
Okay, so
Mm-hmm.
many a times we heard cases that the original will is lost or somebody comes with a new will, okay, etc. All that. So it can be always verified. There's a one registered copy there. Okay,
Mm-hmm.
but having said all that, the law is you can still go ahead and make another will after making your registered will, and that new will can remain unregistered.
Oh, it can. Okay.
Yes.
But
Okay.
will it be valid if it is
It will be
100?
valid. It will be valid. But if you want to make any addendum to the will, we call that as codicil. If you do any codicil to the will, then it has to be registered. Okay.
Okay.
So again, I'll simplify it. If you have made a will, registered a will, but you want to do a addendum to the will or a codicil to the will, okay, then that codicil also needs to be registered. Okay. But if you decide to write another will at a new date, okay, saying that now I want to do a will, okay, which could be very similar or may have a small changes. That new will may not necessarily be registered because the law says you can have unregistered will.
Okay, understood. Okay.
Okay,
So you just say this is my latest will, any previous will is not valid, and so now this becomes
absolutely,
valid. Acha.
absolutely. The new will becomes valid, but
Okay.
then now new will is unregistered.
But new will is unregistered. You'll have to still go through the whole
Still
process of
again go
dealing with
on.
an unregistered will. Okay. So with this probating that is necessary for will, does registration of the will help you get away from the probate process, or probate is still mandatory any which ways?
Yeah, unfortunately, no. Even if you have registered a will, you still need to get the probate done. Okay.
Okay.
Probate is not really directly linked to the registration part of the will.
Okay.
Registration is more to prove the authenticity of the will when the will goes for a probate. Okay.
Okay.
Okay. For the benefit of people who may not know, probate is a process of verifying the will by the court. Okay.
Okay.
Which
Okay.
means that if there's a will, the legal heir will present it to the court and say that, look, this is I left so and so will.
Mm.
And then there are whole number of paperwork which happens. You have to file the petition. There are certain indemnity which might need to be given. After doing all those paperwork, okay,
Mm.
the court verifies. It gives a time for everybody to come and contest, saying that, look, there's a will which has come. 2 weeks
Mm.
time is given.
Mm.
A citation, that means a letter goes to the immediate family member,
Mm.
okay, saying that so and so will has come in the court,
Mm.
okay. Do you have any objection? If there's no objection and if the court is satisfied, then they will grant the probate of the will.
Okay.
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 So when you have this probated will, then you have the legal document to go and
Mm.
claim the entire assets. Okay.
Okay.
But to answer your question again, even if the will is registered, you still have to get the probate done.
Mhm.
And
Okay.
this is mandatory in 3 places, which is Mumbai, Kolkata, and Chennai.
Okay. Okay. In other places, probating is not
Is not
necessary.
mandatory. Is not mandatory. Even for Christians also, pan India, it's not mandatory. For Muslims, it's not mandatory.
Acha.
If you're
Okay.
Hindu, if you have a property in these 3 places or you're staying in these 3 places, then the probate becomes mandatory.
Oh, okay. So this is quite complex now. Okay. This is why I don't think we should venture into doing all of this ourselves. Seek out proper advice on this. So, but there are some
Absolutely.
questions from the audience I want to ask you. Deepak says, I want my wife to be a nominee, and after that, the children to be a nominee. So, is it something that is nomination the right way to go do that? This is a common request, right? As long as my spouse is there, they should enjoy my assets. But after his or her time, maybe the children can get it. What's the best way to do this?
I think he's asking whether you can have an alternate nominee, right? Primary nominee is the spouse. After she passes away, the children become the nominees, after her. I don't know in nomination whether you have that feature, right? I think
We can do multiple
It,
you can
nominations
do
now.
multiple. I don't think alternate nominees are allowed.
I think there is a new some changes which has happened recently, especially in the mutual fund. I'm aware. Okay,
Yeah.
maybe in banks also. I'm not sure. So you can have a primary nominees and alternate nominee. That's successor nominee. Okay, that option is very recently, within last 1 year or so, has been introduced now. Okay,
Okay.
where that option is there. So one is you can have multiple nominee at level one, where you can say a percentage, 30,
Mm,
40, 50, whatever. Okay. And
mm,
second is in case if your primary nominee dies, predeceases, okay,
mm.
then there's a successor nominee option is also available, okay,
I see.
but in
Acha.
not all the financial assets, okay.
Okay. Okay.
So if you have, let's say, I'm not sure about the demat account, I'm not sure about some of the small saving schemes. I don't think so they have. Maybe
Okay.
not even
Only
in
mutual
insurance
funds.
also. Mutual
Not.
funds I'm aware of, and probably in banks also. So there are options available, not in all the financial instruments. Okay.
Okay. But if Mr. Srivastava wants to actually do this, meaning ensure that the spouse and the children don't ever have to, struggle through this process, what would you advise them?
Absolutely. See, while nomination makes the process of claiming the asset, which is what Ravi was saying, that nominee can immediately go and claim the assets. Okay.
Yeah.
So the liquidity is provided. You have the assets with you.
Mm.
But the law says that nominee is not the ultimate beneficiary. Okay.
Okay. Okay.
Let's take a case where there are two children, wife and mother. Okay.
Mm. Mm.
Now, if let's say he's made his wife as a nominee, which is what most of us will do, okay, and there's a substantial amount of money in this particular demat account, let's say, okay, wife will go and claim and take all the securities.
Mm.
But the law is the mother also
Mm.
has a claim because there's
Yeah.
no will. Okay.
Mm.
Now the
Mm.
mother will either need to give a NOC or
Mm.
she needs to she will collect the asset. Okay, what
Mm.
the law says.
Mm.
Now, in the absence of a will,
Mm.
the wealth will be distributed equally between class one legal heirs. So
Mm.
first important point is if you have a will, you can very clearly say that after me everything will go to my wife
Mm. Mm.
or after that to children. Okay, so this power
Mm.
of deciding who gets actually which asset after me,
Mm.
okay, and in the sequential manner, first to so and so, then to so and so, and then to so and so, can only be achieved through a will kind of document.
Mm.
Okay,
Can only be done
nomination
through a
will
will.
not do that. Yes.
Okay, okay. So, Mr. Srivastav, I hope that answers your question. If this is your intention, please get a will written. Nomination will probably not solve it for all of your financial assets, right? So, Virabda is asking a question. What is this no contest clause in a will? Is there something like that? No
Yeah,
contest.
see, no contest clause we normally put in all these things. It's more a deterrent for any kind of frivolous contest by any beneficiary.
Okay, okay,
That if they contest, then they lose rights to the estate.
okay,
But
okay,
having said that, it's a fundamental right for every person to contest,
okay,
challenge a will. You cannot stop.
okay,
And there are instances where the courts have allowed, especially when it's been challenged on the grounds of a fraud or a
okay.
coercion. Now, Sanjay Kapoor, everybody must be following this Karishma Kapoor's case, right?
Mm, mm, mm.
If there is an allegation of a fraud or anything, the courts will entertain the suit
Okay.
from anybody.
Mm,
But then that person should be very sure that
mm.
there is a solid basis for challenging the
Okay.
genuinity of the will.
Mhm.
And if it's found that it is genuine, then that person may lose rights to the estate. In
Okay.
case of Ratan Tata, if you remember, his colleague, ex-colleague or friend Datta, somebody was one of the beneficiaries.
Mm, mhm.
But of course, technically, he didn't challenge the genuinity of the will.
Mm,
He wanted a kind of court to interpret a certain clause which allowed a greater share of the estate to come to him.
mm,
It's
mm,
more
mm,
about whether the interpretation of the distribution of the
mm,
estate
mm,
is correct,
mm.
or the court needs to give a clarification so that he gets more of the estate. So
Mhm.
then that's a gray area, whether you are really contesting the will or you're just contesting the interpretation of the will,
Mhm.
right? But anyhow, it was amicably settled, and I think he just took what was given. Uh,
Okay.
yeah, so these are very fine lines. You can put it in as a deterrent so that but people have to understand. Number one is who can challenge a will, right?
Mhm.
And on what grounds you can challenge a will.
I
So
see. Mm.
only the class one legal heirs can challenge a will.
Okay.
Okay.
Mm,
It's not that your servant can walk in and say he had promised he'll give me so much share and challenge the will.
mm,
Right?
mm,
Or your neighbor say, or his girlfriend comes and says, I'm challenging the will.
mm,
You cannot. Only the class one heir, which is the spouse and the children and the
mhm,
mother, if
mm,
surviving, can
mm,
challenge a will. Nobody
mm.
else can challenge a will.
Okay.
And
And
they
on
can
what grounds can a will be challenged?
only challenge it on grounds of a suspicious will, that the will is a forged one. They
Okay.
cannot challenge on any other ground. Yes,
Mm.
sometimes children have challenged on the grounds of disinheritance. That is, they have not got any share in the will
Okay.
by the parent. And
Mm,
they challenge saying that, how can my parent forget me and
mm,
not give me anything?
mm,
And
mm,
therefore, those are but different kinds of things where the court
mm,
then, feels where the child is entitled to something and looking at it.
mm.
But yes, only class one legal heirs can challenge. Nobody else can challenge.
Okay.
So
Okay.
we always keep all these things in mind when deciding on whether the will has to be registered.
Okay.
We say, what are the chances of it being challenged? Who can
Mm.
challenge it? If we think
Okay.
there is no reason for the children to challenge, we then don't put them to the registration costs and
Okay.
hassles.
Oh, okay. So you're saying registration also is a subject of advisory, meaning you can
Yeah,
decide to sometimes register and choose not to register as
yeah.
well. Gotcha. Okay.
See, if
Interesting.
I know, we can give practical examples. Like a client had who recently passed away, had a estate in property in Pune.
Okay.
The will is not registered.
Mm.
Pune probate is not compulsory. When we
Okay.
go to the registrar for transferring the property to the wife, the
Mm.
registrar says either the will is registered or you go to
Mm.
the court and get me a court order saying the will is genuine. Otherwise, he said, I have no way of knowing this is a forged will or a genuine will, even though it's going to the spouse.
Okay.
If it is registered, at least we are willing to accept because it means that it's a genuine will. So sometimes registrations, the advice also based on where are your assets located and what are the chances that a registered will be accepted in the other towns and cities where probate is not compulsory. So there will be fine lines, right?
Interesting, very interesting.
Just,
Okay.
Mona, just I want to add up on the initial point of the no contest clause. Okay,
Yeah.
the actual case which I'd handled way back in 2014-15.
Mhm.
So this gentleman who was one of the big shot in a big firm had assets around 40 odd crore. Okay. He was fighting a divorce battle with his wife for last 13, 14 years. Okay. And he was staying with another lady for that many years almost. And there was a intent to do philanthropy and various other assets. When I met him, so he said, "Look, this is what my situation is. Uh, it's a very bad dispute which is happening. We're trying to come to some terms, but it's not happening. But I need to write a will. So if something happens to me, the asset goes to the person whom I really want to, not to the person with whom I've been fighting all this while." Okay. So when we drafted the will, we said, okay, there's a house which he was staying into, okay, around 2.5, 3 crores. So we together decided that house should go to her, even whatever the fight is there. And some small amount, I think 25, 30 lakh rupees. Okay. And we wrote in the will. Unfortunately, within 2 years, this gentleman passed away. Okay. And then we put a no contest that this house will not go to her if she contests the will. Okay. If she doesn't contest the will, this house and that sum of money will go to her.
Gotcha.
So actual case happened. We dealt with it and then we told her, look, this is what it looks like. Tell us if you want to fight or not. She eventually decided not to fight.
Okay. Okay.
The
At least
whole
the house
rest of the
will get.
asset was protected. And the house she got, this she got some money, okay,
Okay.
because then now she had something to lose if she
Yeah.
continues. Otherwise, nothing to lose, only to gain. Okay.
Okay.
So
Yeah.
sometime, as Ravi was saying, this acts as a deterrent. And
Okay. Okay. Interesting. Good. Good. Great. So, we'll just get into the little basics of how can somebody write a will. Should it be done on a stamp paper? Who should be witnesses? Who should be executor? So very quickly, if you can just take us through it. Of course, we would not recommend anybody to do this by themselves. We would want them to seek advice and take expert help on this. But if you can just let us know how easy, difficult it is.
Sure. So there are very basic of the will is any document where you put your desires, what happens to your assets after your death, okay, with certain important points being covered is a valid will. Okay. Now, what are those important points? One is first thing, the person obviously has to be competent, okay, which means major sound state of mind standard, he has to be competent. Okay. Second is there has to be an asset, okay, there has to be property, okay, to call it as a will, right? So there has to be property to be called as a will. We need to have some asset, okay. Then third is the will has to be dated, okay.
Okay.
Very clearly there has to be a date in the will. Okay, if there's no date, then it will become invalid. Okay. Next is obviously it has to be signed. Okay. It has to be attested, signed, and we advise that signing on all the pages like typically you do for the agreements. Okay. Sign and put a date there. Okay. Last is you need to have a witnesses. Okay. Two valid witnesses. Okay. Who are also themselves competent. Okay. And who should not have a conflict of interest with the will. Which means that
they
people
should
who
not
are
be
going
beneficiaries.
absolutely. So they should not be a beneficiary. So
No.
no conflict of interest of the witnesses. And these 3, 4 points which you ensure, okay, the will is kind of valid.
So
Okay.
stamp paper and all is not necessary.
Stamp paper not needed, registration not mandatory. Okay. You don't need to have a green legal paper. All that is not needed. You can handwrite it, you can type it. Okay. You can have in local language, you can have in English. Okay. All that is there. And for academic purpose, even the oral will is allowed. That's called a privilege will. Okay. But only available to situations where gentlemen in defense or in situation where they feel that they can't survive. Okay, these are typically available to certain firemen or people in defense where they can tell their colleague that I'm giving these assets to two of them, and if they testify, if the court feels okay, even the oral will can also be valid with that exceptions.
Okay, interesting. Okay. So what if the witnesses die? So that's a question. What happens then?
No, so actually, there I just saw that question pop up here on the screen. So
Mm.
obviously, we are right now dealing with a live case where both the witnesses have died because my client's parents died more than 10 years ago. He never did anything about it. And now,
Okay.
one fine day, when he tried to sell his house in Chembur,
Mm.
he realized that, the buyer is saying, was your society, your membership has got transferred, but the property is still in your mother's name.
Mm.
And the witnesses have also died because his father had used his office colleagues as witnesses, and so they are no longer traceable. So when
Mm.
you go to the probate process, you take the will to the court,
Mm.
and the court says, okay, at least one witness should be alive, and
Mm.
you don't have either of them, then the will fails.
Mm.
Then the court will accept the probate application, but then there is a whole process they will go through to independently verify whether the witnesses are alive or dead. And
Oh.
that is, again, 4 months, 5 months.
Oh.
There's a legal costs involved. There are advertisements to be issued.
Mm.
So at that time, we just tell our client, forget the wills. We will just go assuming there are no wills by your parents,
Oh
and
my God.
we build a whole strategy around it, and how to tackle it. Because if both the witnesses are dead, then too bad. I mean,
Well, okay. Okay. So it's better to name somebody who's like much younger
much
or
younger,
something.
and consciously see where are they. And most important is whether it's your spouse, parent who have passed away, you should act immediately. People don't act. They just sit because they think, okay, the house is there, I'm continuing to stay in it, or whatever it is. Don't bother. Later it will cause problems. So then the cost goes up. So
Okay.
people should act
Okay.
very quickly.
Yeah, meaning it's usually not so easy to act, right? So they're probably grieving and stuff like that. So,
Yeah. No, that is fine. I'm saying at least within a year or 2 years. I'm
oh,
not saying immediately.
okay, okay.
Don't
The
sit on
law
it.
allows you three
Hold
year.
on.
The law
Oh,
allows you a 3 year of limitation period,
okay,
okay, to file.
okay,
After that, if you file for a probate of the will,
okay,
then you need to answer, really explain to the court why there's a delay which has happened.
okay, 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 good.
But
So
the
there.
sooner the better, which is what we advise.
Okay, okay, okay. So understood. So that answers Srinivasa's question. Prem is asking if term insurance can be part of the will. Of course, I think it can be part of the will, right? It's part of the estate. Okay. Srinivasa, the question of registration of the will was answered. The answer was that registration is not compulsory but desirable. And even if you want to make a fresh new will, it's okay if you do not register it, but desirable in many cases. Shailesh has asked a question. Most of the time, out of three children in a family, one child takes all the movable assets by being close to one of the living parent and makes a will in favor of the child, excluding the other two children. So, how do we face such situations to ensure that children get equal benefits? Is there something that lawyers can do about this?
Yeah, see, if it's only case of a nominee, if one of the child has been made nominee and
Mm.
he takes the asset, then obviously there's a clear legal recourse available where you contest in the court and the court will say you are just a nominee, you have to distribute. Now, if it's a situation where he makes his father or mother write a will,
Mm.
okay, and with valid witnesses and everything,
Mm.
then obviously still there's option available. Okay, why this was done,
Mm.
there's a natural law of justice, okay, how the asset should flow. You can still contest, but as you said, yeah, then the lawyers will go and contest and build up a strategies and how to fight it out. But it's going to be difficult where there's actually a will which has been written for.
Okay, okay, okay. Good. Thank you very much. I hope that answered your question, Shailesh. There's another question that Jeet is asking. He's an Indian national. He lives in the Middle East, and he's asking. He's got assets in different parts of India. Where should he register his will?
He should register a will wherever there is a address proof or a house where he stays normally. Okay, when he comes to India, whichever location he stays, wherever his residence is,
Okay.
okay, that's the place where the will should ideally be registered. Okay,
Okay. So, I mean, let's say it's in two, three different states, and he does stay alternatively, sometimes here, sometimes there. Uh,
either of it,
either of it, or
either of the place you can
should he just pick a state where the complexities are lesser?
probably. Probably.
Probably.
You'll have to also keep this in mind, though, if it's one of the places which I just said, where the probate is mandatory. Okay. The other places, the probate could be either not mandatory or the cost could be high. Okay.
Okay.
So you'll
Okay.
have to evaluate what is the cost of doing the probate. Some places it is not, like in Mumbai, it is percentage, which is 6%, but capped at 75,000 rupees. Okay.
Okay. Okay.
Where if you go to Delhi, I think it is 3% and there's no capping. Okay.
Oh, okay.
And
Okay.
there are certain places where probate, if you go, there's a huge cost. Okay. So you'll have to really evaluate. Like I think UP has 4%, if I'm not wrong. So then if you have option, then probably you may want to choose which place.
Yeah. Okay. Jeet, I hope that answers your question. Maybe you should just reach
Now,
out to.
maybe I can just add a small, you can
Sure.
use to tip in case is always, the three cities where probates are mandatory, by Calcutta, Chennai. Because the probate process is so well formalized now and well followed, understood by the legal professionals, the sub-registrar's office and all. It always, these cities, the whole process is much more structured. The sub-registrars also know things about wills and all that because they are dealing with these day in, day out.
Okay.
Right? So these three cities are always preferred if you have an address proof there. That's what we normally suggest.
Okay.
The whole legal ecosystem around estate planning is very well developed in these
In these
cities.
three cities. So it's better if the property is in one of these
If
three
you
cities.
can,
you
if you
would
can do
recommend.
it.
Yeah. Okay. Good. Got it. Abhishek's question is, I hope, Jeet, that answered your question. Abhishek, if parents have one child and nomination is mentioned in the society nomination form, is a will still required? Okay. So Abhishek's background is that he's probably the only child, he or his, and then there's no other heir, there's no other complication. There's just one property, nomination is mentioned in the property, I mean, in the society. I know you said that even though nomination is there, transfer of assets will not happen just because nomination is there. But we have anything specific to tell him?
No, I think the question whether a will is required or
Yes, his question is whether will is required.
it is him and his parents. Is that what it is?
Yeah. In case he's the only child and there's only a property, and
Property
he's
and
nominated.
so basically parents and him, suppose. Okay.
Yeah.
And let's say the parent who owns the house passes away, then
Yeah.
he and the surviving parent will become the co-owners.
Okay.
If you don't have a will,
Okay.
and one of them has to move the application for the probate. If the mother is surviving, normally we advise the mother to move the application because there is a court benefit in court fees when a widow files for a probate in Maharashtra. So
Okay.
these are the fine technicalities we advise. Or if there is a will, the advantage of a will is you can name the executor. So father can say son will be the executor, and so a will has its own benefits. But if he says no, I don't want a will at all, and only me and my one of my parents will be around, and but you will have to go through the same process, right? So that is nothing that we are really
There is
doing.
one case, Ravi, which I dealt recently. My friend who father passed away long back, mother and only son. Okay, only son. So we did this case, and obviously there was no will. Society needs to be very sure that he's the only son and there are no other claim going to happen, because now they are doing it only based on nomination. Okay. So what society typically does, and it can be different in different society, they will have some kind of indemnity and there are certain fixed forms and all. They will take certain documents from the son, okay, stating that confirming that these are the only legatees, okay, and they have a discretion then to issue the certificate in the name of the only son if they convince and they have taken all the document to protect themselves in future, okay. But generally societies, and it also depends on the value of the flat. Very large value, 4-5 crore, so that is clearly nothing doing. Get me the letter of administration, okay, which is a case where if you don't have a will, then you file for letter of administration. Okay.
Okay.
So they will ask for one of these document or succession certificate in some places for a movable asset. Yeah.
So whether or not a will, the will is probably easier than getting the letter of administration or the succession certificate, right?
Slightly, yeah. It is.
Okay.
See,
So
people sorry to interject there, but
Sure, sure.
people also look at, in a situation as you just mentioned, father, parents, and son.
Yeah.
So the one of the parent passes away, who's the owner of the house. Instead of going through a letter of administration or a probate, we normally there is a release deed route also that is available, which can be used. Let's say, just take a hypothetical situation where the father passes away, owns the house. The son can give a release deed in favor of the mother. That's a more inexpensive process, and at least ensure that the mother becomes the legal heir of the property. And then, the membership also is given to the mother. But if the
Okay.
mother is also old, then, we recommend the reverse. The mother gives the release to the son. So
Okay.
otherwise, you have to go through the whole process again.
Okay.
So, but
So you'd say better get that will done, right?
yeah, because see, we have to see the age profiles of the parents also,
Ah.
right? So suppose the father is old, mother is also very old, and you do a release. At that point, after the father passes away, mother, whether she's in a position to visit the registrar's office, because release deed, the mother has to go
Oh.
physically be present. If she cannot be present, you have a problem. The registrar will say, bring her on a stretcher, bring her in an ambulance, but she has to come. Right?
Okay.
Now, these are practical challenges. Whereas if there is a will, and the son is the beneficiary, then the mother needn't be brought into the picture at all.
Okay, understood.
So
Okay.
these are fine things that we look at while advising on the estate plan strategy for a client.
Correct. Perfect. Okay.
Practically.
Abhishek, I hope that answers your question. There's another question from Mr. Marti. He says his entire family are foreign nationals. He, his wife, his children, some of them are in the US and Netherlands, and they have properties in India. So, uh, I mean, how complex is this situation? What is the right approach? Where should the will be registered? If he has assets outside the country, will the will be valid there as well? I mean, what is the scene on this? You can very quickly, I know this is very complex. We don't have to go into all of those details, but if you can broadly tell us what's a good thing to do.
Shailendra, you want to take the question?
Sorry, I missed it. Can you repeat? Sorry.
Or okay,
Yeah.
I will just tell that the client has got basically a foreign national or
His wife, his children, everybody are
foreign
foreign
Everybody is
national,
nationals.
fine. Okay.
and
They
they
have
have
assets in India and in foreign countries
foreign
where
country
they are.
wherever they are. So they want to know what's the best estate planning
But they
advice
live in
we
India.
give
So
them.
he and his wife have lived in India the last 10 years.
So if
Now
they
they
have
are in
assets in
India. Are they in
India,
India now?
Yeah, they are in India. I think they intend to stay here.
so if they have assets in India, okay, so wherever they're staying, okay, the only thing is when you are going for registration, okay, while OCI card and other documents is fine, if they may not have Aadhaar, or in most of the cases, NRI don't have Aadhaar, they will still need to give a proof of residence here, in the sense where their nominees stay here. Okay, that could be a lease deed, that could be a electricity bill in case if they've owned house. Okay, then whichever is the registration office falling in that area, it can be registered there. Okay.
Okay.
Yeah.
Okay.
So registration is possible. We have to see what is the document, but the one proof of residence has to be given along with the identity proof, which could be standard uh, passport, and you don't really need Aadhaar there. Even PAN card, most of them will have, so that should suffice.
Did we lose Shailendra?
No, I'm
Now you are audible, Shailendra. Yes.
okay. So I just I'm not sure what you heard. I was saying address proof of the residence along with identity proof is good enough to go and register your will. Okay.
So having said that, no, I think, can you hear me now? Can
Now
you
I
hear me?
can hear you. Yes.
Okay.
Okay,
So
I think
what
we are.
Shailendra is saying is that if he's staying in India and he's got some address proof wherever he's staying in India, obviously, I don't know whether the passport, Indian OCI card, whatever, where the address is shown, I'm not sure. But some address proof you need if you walk into a registration office saying, I have a will and I want to register it, they will ask, okay, why are you coming into this office? What's your this thing? So you will have to produce evidence that you live in that vicinity, and then they will agree to register your will there. You need to have some proof. Now we'll have to go into the specifics of the particular case to advise. And as
No,
far as
assets in foreign countries also can he bill it
absolutely,
here?
you can
Can
do
he?
it here, but better is to write separate wills for different jurisdictions. We always say because each country has its own processes for estate transmission. So it's better you write separate wills for separate jurisdiction, because if you do a same will here for overseas and here you put it into probate, your original will is gone. So till you get a probate order, you cannot touch your overseas assets. And then this probate order has to be sent out there. There again, there's another process. So it just becomes too expensive and too time consuming, and there's a big delay. So we always advise separate wills for separate jurisdictions.
Okay, okay. So I hope that helps, Mr. Marthi. Sudhir is asking a question. I have a will from my mother to me and signed by my brothers as witnesses. I hope this should be okay, as I intentionally made them witness to avoid them raising any issues subsequently. Kindly clarify, is this correct?
Yeah, witness can be no problem. I mean,
His mother's will, his brother is the witness. Wouldn't he be a beneficiary? Isn't there conflict here?
So see, depends on as Hindus can have beneficiaries as witness as per law. The
I
will
see.
is not rendered invalid because of that. The
Okay.
problem will come if the will is challenged. Then, if the beneficiary is a witness, the court will look at it very suspiciously. They will call it as you need to lead solid evidence that the will is a genuine will. So if there is a chance of a contest, better avoid beneficiaries as witness. But as far as legality is concerned, it's a perfectly valid will.
Acha. Okay. Okay.
I think one important point, sometimes what I think what people do is they make the immediate family member or one of the beneficiary as a witness just to confirm that he has seen the will. Okay, the idea probably would have been to ensure that the brother doesn't contest this.
Yeah, that's what he mentions too.
So which is not the correct thing to do. While if the will is not contested, it will sail through. Okay. But factually, there could be a conflict of interest situation because brother being the witness. Okay. So generally we advise that do not make the immediate family members as a witness. See, if it gets contested, then what you do? You make a will as if it will get contested, and you take all the precautions. Okay.
Okay.
All our wills are made as if it may get contested. Then do I have a strong will? I can't be making a will, it will not get contested. So as advice, we always say, do not make immediate family member as the witnesses, because if it gets contested, then you have a problem situation.
Okay.
Okay. So avoid immediate family member as the witness.
Okay.
Okay.
Who do you think should ideally be the executor of the will? One of the beneficiaries is good, right, as an executor?
Absolutely. So it depends on a situation. It's a slightly maybe complex point because executors can be anybody. Okay, even your witnesses can be executor, your doctor can be executor, your beneficiaries can be executor, third party can be executor, a company can be executor. Okay, so executor actually can be anybody except for you. Anybody can be executor, right?
Okay.
Okay, so so it's a very important aspect to look at. A lot of time people do not give enough importance to this aspect of it, because you need to keep in mind that it is the executor who's responsible to ensure that the will gets implemented. The entire process of petition filing, probate, after probate comes distribution of assets. If it's a large estate, you may have to open an account in the name of the deceased. Okay, estate of so and so, get a PAN number in the name of the deceased. Okay, for larger estate, you have to do a lot of other things. You have to hold property for a few number of years till the time it gets sold. You may have to sell the property. If it's a business, you may have to run the business for ongoing purpose, appoint CEO. So it could be a very, very challenging thing. Okay, so executor is a very important aspect of it. Now, who should be executor? If it's a very small, simple family, if you feel there's no chance of contest, then you can make the beneficiary as an executor, because they have an interest. They will do all the paperwork. They better do it to get the money. Okay. In a very plain, simple terms, in most of the cases, you can make the children as an executor. Maybe even wife or husband, that is spouse, can make each other, but we always tell them that, look, you guys are growing old. When one of you die, probably the other may not be physically fit or are capable to actually do all this work. So keep that in mind. Okay. So better to make a children as an executor is the first option. If there are chances of any kind of dispute or any kind of bad relationship, then you make an independent person as an executor.
Okay.
or independent company as an executor.
Mm,
Okay.
mm.
What you should not do, any other person who may have an interest in your estate to bring an executor.
Okay.
Okay. So I'm handling this case as it is still on. Okay. This gentleman made a will. Okay. And he made his son from the previous marriage as an executor in this new will. Okay. And he was not giving anything to this son. Okay. He thought they're sibling, there'll be good terms. And I don't know for what reason. Okay. So step brother basically was an executor of this will. And obviously, when this person passed away, they were not in good terms, and the will is going through a difficult phase. So while his thought must be ki I'm making my another son as an executor to the will, but that's not right. So you have to also keep those things in mind that unknowingly there is this person also having an interest. If he has done, then he will do everything to not to execute the will.
Not to execute the will. Yeah.
To
Jeopardize the
avoid that.
process. Yeah.
Yeah.
I know. Yeah.
Various things has to be kept in mind. Yeah.
So, I mean, I like the point that you said you prepare the will assuming that it will get contested. So, what are different
Absolutely.
ways in which it can get contested and then provide for enough support, right? I have a question. I have about 5 or 6 more questions. We'll see how much we can take. So, Ananda is asking if we have one flat in which is jointly owned between me and my spouse, and we have 2 children. There are 2 questions. First is my will, do I put value of that flat at 50% and so does my spouse? Second question, is it that both of us have to define one child because immovable property cannot be divided in 2 parts? But how do we achieve that after I pass away, my wife gets it, and after she passes away, the flat is sold and the proceeds is equally divided between the 2 children? I think this is like very classic, right? I own a property.
Very classic case where you immediately first you give to the primary beneficiary, which could be spouse. Okay. So you have to write a will in such a way and say that all these assets I'm bequeathing to my spouse. In case if she predeceases me or we die together, then to my children in so and so manner. Now, in case of immovable asset, and which is what the core of the question is, that it is you can give to them together, okay, and you can't divide it the house, right? They will be a co-owner of the house, okay. Having a siblings that also matured, having their own life, having their own objectives, co-owner in one house could be a challenging in future. So what we advise is if there's a way to handle this, which could be if you have a two house, you make one child as a 100% beneficiary of that house and second one for the other. Okay. There could be difference in the value. This typically says this is highly valued, this is low valued. Then we say, okay, compensate this boy or a girl with some liquid assets, and you can write a clause in the will which says that my intention is to give equally. I'm giving a house to so and so. Any difference at that time in the valuation will be compensated by so and so asset by giving a liquid assets. Okay. So that is one way of dealing with it. Okay. So eventually, what you need to keep in mind that whatever you are writing, okay, that things will change. I mean, the children will get married, they will have their spouse, so there are good chances of contest happening, especially if it's a core house which is very highly valued. Okay, there one has to keep in mind that how do I divide that? So one is obviously this. Second, sometimes gifting assets in the life could be a solution. Okay, we say that if you have multiple house, you gift one of the asset or both of them so that they have something with them. Okay, but it's a slightly tricky on a case-to-case basis. We'll have to advise. I mean, it's not a straightforward answer to say so.
Okay.
It depends on the objective. Yeah.
Okay. So, Ananda, I hope that answered your question. So, Jeet wants to know, is there a way to, for the spouse to know the details of all assets? Is there any way to find out if a person dies and his legal heirs would like to know all the details? I mean, I don't know if the question implies that there is a will or there is no will, but I'm presuming if there is a will, there is a list of assets, right?
Not necessarily. A lot of people write, that all my assets will go to my wife. They want shortcuts. So later the executor will struggle to identify. But now I think you have these account aggregators who pull out a lot of the assets from the government records. But perhaps maybe not all, but most of it you will get as far as movable financial assets are concerned. House and all better to, I guess that's not a problem. I know, unless you are having a whole, portfolio of real estate across and then the executor struggle. You have such rich clients also, we have come across, but I'm saying generally middle class, upper middle class typically will have a couple of houses, so that's not a problem. Movable
Uh,
assets you normally get through account aggregators, but financial advisors like you, I think the best people to uh,
mm.
give them the information that they need at the right time.
Correct. So, Jeet, if that's a question. While preparing the financial plan for all our clients, we do collect details of all the assets, and this is one reason why we really do it, right? So, the whole process of estate planning becomes easier. The details that are required for preparing the plan can be provided by us also. You don't have to go through the whole process one more time. All that you have to do is identify the beneficiaries and decide who gets what and how much, and then we can move on to preparing the necessary documents. So I hope that answers the question. Shija asked an interesting question. Would an LLP structure holding all the assets work better than nominees, etc.?
See, here one has to understand LLP, I guess referring to a partnership, right? An LLP is a limited liability partnership he's referring to. But partnerships are normally only for business ventures, right? It's a partnership is a partnership in profit and loss.
Yeah,
So you
yeah.
can't use it for holding
Yes,
assets,
yes.
right? And you get into RBI problems because it will be treated as an NBFC and definitely not an LLP. You can think of a company, but you will have to then apply to RBI for NBFC license. They call it a core CC, they call it. So there's a special license for that. You'll have to apply. So it's not an idea. You can have structures like an association of persons or body of individuals and a way of holding the assets. But how that asset transmission works, is a different ball game. There obviously it can't be because even if you do an AOP, then every partner, her share has to be transmitted through a will. It's not that, it just goes to the other partner.
Okay.
There is a transmission process there also. Like in a simple partnership also, when one partner dies, his share or her share will go as per the will. So it
Yeah,
can't just go to the other partner.
Yes, yeah. Okay. Of course, the partner can leave their share to somebody else also, right? It need not necessarily go to
Yeah,
the
but
other.
you can't use it for holding assets. It's for a business venture, LLPs. So
So, Shija, it's probably a more complicated process than actually writing a will. A will is probably going to be a lot more easier.
I think somebody has been asking repeatedly. I saw whether will and a settlement deed.
Okay.
What is the difference? I think that question is. I saw it couple of
Okay. Yeah,
times
sure.
now
So let's
on the
go.
screen.
Okay.
So I think people have to understand the word settlement
Okay.
itself means there is a dispute. You're settling something. Right? The General Clauses Act comes into thing. So court will use what is the settlement? Settlement is when there is a difference, right? On a right to something. So then you settle through a settlement deed. So I cannot have my distribution go to my children through a settlement deed because it's my asset. They don't have any interest in my asset. Only I can decide who will get what. Settlement deed comes in typically for ancestral properties when all the legal heirs have claim to it and there is a dispute, and then they through a settlement deed decide how that
Between
right.
each other.
Yeah, then a settlement deed comes into play. But it cannot be, it's not a testamentary document to transmit your self-acquired assets
Okay.
to your children or to any other family member.
Okay. Okay.
It's not it will be then treated as a gift deed, if at all. Okay.
Okay.
So,
Understood. Okay. I hope, Satya, that answers your question. So this is interesting. Jeet, I think this question was answered. Is the registered will valid and effective outside India for assets held in UAE? So he did answer it saying if you have assets in different jurisdictions, it's better to go through the estate planning process for those respective countries independently because there is going to be one will document. You send it in for probating. You don't now have a document, so you have to wait for the probate to come, and then there might be another set of whole processes in the other country. So write two separate wills for assets in the respective countries was the answer. Shailendra, that was right. Did I?
Yeah, absolutely.
Okay.
Yeah, that's correct.
So, Pattabhiraman is asking, how will executors know that they are the executor of the will? They are never made, they don't have to be informed, right?
Ideally, one should inform them because while there is no written consent is required to be taken, but as a good practice, one should take.
Mm.
Okay. Especially if you're making third person outsider as an executor.
Mm.
We have a executorship firm. So whenever we enter into an executorship, what
Mm.
we do is we obviously have a letter of engagement with them where all
Mm.
the terms are written. Okay.
Okay.
Because we are professional companies, so there's a commercial term also. In case of individuals or friends, there will not be commercial terms, but still it is a good practice to at least tell them. Some
Mm.
people go ahead and take a consent while he can still later on say no. Okay,
Mm.
that I'm not willing, that is all right.
Mm.
Okay. And if not, then at least tell them that there is so and so will and you are an executor. In some cases, a copy of the will can also be given to the executor if he is a neutral third person. Okay.
Okay. Okay.
Or even original will can also be kept with an executor. If it's a law firm or if it's a trusted person, what people do is instead of giving to one child or two child or to the family member, they actually give the actual will to the executors only.
Okay. And is it necessary to leave something like part of estate for the executor for the services that they do? I mean, does it make sense?
Doesn't make sense. Ideally, this should be based on commercial terms of fees. You can agree. You can write in the will that I'm giving X amount or so and so from my estate to executors for doing this work.
Okay.
Okay. Or it can be a separate arrangement also. Okay.
Okay. That can be
Some
separate.
fees, whatever, if you're keeping it is good enough. Even
Mm.
if you're not doing, obviously it's not mandatory. But all said and done, eventually, after all this also, when the will comes for a probate or
Mm.
execution, the executor has full right to say, I won't be able to do it.
I won't be able to do it. Okay, that's possible. So I hope that answers your question. If the executor refuses to execute the will, the beneficiaries in their own interest will have to pick it up and execute the will if they want the money, right? So that's where it'll end up. Is mentioning an executor in the will compulsory? That's a question. I guess the answer is yes, no?
Uh, I mean, it's not that if you don't write an executor, the will becomes invalid.
Acha.
Okay.
Okay.
The will not become invalid just for absence of this clause.
Mm.
But then you are adding one more step where now who's going to be executor? Okay.
Mm.
So then
Mm.
now the court will appoint executor. So somebody will have to approach to a court, okay,
Oh,
either one
court
of
will
the
appoint executor.
beneficiaries,
Okay.
okay, saying that for this will, I want to be an executor, I want to be a letter of administrator. Okay.
Okay.
One of the beneficiaries. So you're adding one extra step. This is assuming that the beneficiaries are in good terms and they agree to one person being an executor. If they don't agree, then it's a different fight altogether.
Mm. Mhm, mhm.
Okay.
Okay. Okay.
Yeah.
Understood. So an executor is necessary, whether or not mentioned in the will. It's better to mention in the will. Otherwise, the court will appoint an executor. Okay.
Yeah.
So Ananda's asking, how about making an estate planning company the executor and the retainer of the will? I don't want my children to run around and disposing the movable and immovable property to execute the will.
So, executorship firm or a trustee company or executorship company is unfortunately not so popular in India. Okay, there are a few very handful of companies who do this work. Internationally, it is a big business, and there are a lot of executorship and trustee company, and I'll say large number of people actually give this work to executors. Okay, in India, it is not still that evolved. It's a good thing. Prima facie, the answer is good thing. Why? Because you have a independent firm who does this day in, day out. They know the whole process. They have team of lawyers and people on feet on seat to do all this work. So it's a good thing to do. And also there's no conflict of interest.
Mm.
Only downside is there's going to be a charge to it. There's going to be fees for all this. Okay.
Obvious.
And in some cases, in case if executor is not capable enough or executor has gone into a difficult situation because of the company not doing well or a dispute between the partners or XYZ, then you may have a situation where the executor is not able to do their work. So you should be very careful when you appoint an executor, which is what I said earlier also.
Okay. Yeah. By the way, Ananda, Plan My Estate, our advisors, they are the planners as well as they would prepare the will, and also execute the will. They also offer execution services. So
Right.
you might reach out to them. Harsh is asking, is it possible we can have a standard draft of will which we can help us cover everything while writing our own will? Like a sample.
No, so, as we told, yeah, I mean, you have a lot of templates going around on Google websites. You can Google and you can get a lot of templates.
Mm.
Or you have online bill writing services. And if you're clear of what you want to do, how you want to do, and you have answers to all your doubts and questions, you can just do an online, or you can do a copy paste from a lot of the websites. You can just nowadays with AI platforms, you can just say, please write my will and give the details. It will write a will for you. So that's not a problem. But yes, but just be sure that you know what you're getting, and there'll be no issues with this later when it comes up for execution after you're passed away. So
Yeah.
that
So,
that's a call you have to take, right?
So, Harsh, it might sound very easy to just take a sample of the will and prepare it now. But remember, the people who will be executing the will not be you. You won't be around when the will has to be executed. Children and maybe spouses will have to execute that will. If you don't want them to have struggles in doing it, it's better to go through somebody who knows what is being written there. This is like saying, can I have a sample financial plan? I'll just plug my data and then prepare my financial plan. It doesn't work that way. Every will is probably, it's worthwhile spending that time and that money in getting one will done if you really care for the family. This is basic minimum that you should do is what I'd like to add a little bit. The copy pasting of a will document is not something that's good practice, right? Am I right, Shailendra?
Yeah, so in fact, yesterday I was with one of the CXOs of Kotak Mutual Fund. So he was saying that we want all our distribution partners
Mm,
who have a preferred estate planner for all their clients, because nowadays the financial assets are worth 4,
mm,
5 crores, and it's increasing. And in the next 5, 10 years, the asset will be real substantial
mm.
size. And he says, I fail to understand why people risk such a large corpus
Yeah, yeah,
and leave it to chance, and not spare, try to save on that 15, 20,000 for a good estate planning advice.
yeah.
He was telling me, I see India going the US way very soon, where you'll have real, every financial plan will have an estate plan with it,
Absolutely.
right?
Yes.
Professionally done.
Yeah.
And he says that's why we think you all are in a very sweet spot, and you guys need to build
Yeah.
this
I
practice.
think we should also do that, not make it optional at all. Unless somebody says, oh, yeah, they have a will and they can, give us a copy of the will, make it mandatory for people to write the will and embed it in the cost or something like that. We think about it. This is taking a lot of risk as we see and putting the family through trouble. Kashmira has a very interesting question. He says she has multiple assets. She has only one son. She has a will in which the son is named as the sole beneficiary. However, she's considering whether it makes sense to gift the child all the property and save them from the effort of going through the whole probate drama.
Yeah, how old is the child, if I may ask?
He's an adult. I mean,
It's a
probably.
major, right?
Yeah, yeah.
So as I told you, a live case where the father is debating his cancer and gift it to the son and save the whole probate hassle of a probate process for the son, because he
Mm,
stays in Canada. Yeah,
mm,
he doesn't want him to go through all that difficulties, because he's
mm,
just got through that whole process inheriting from his mother. So he
mm,
knows all the challenges that come up. So
mm,
he's saying, I would like to gift it. And I said, yeah, do the gift. But that's where I told you, then we need to evaluate the tax implications for the child after he takes the asset, whether you want the income coming out of it during your lifetime. But
mm, mm, mm.
right, so all those things have to be the cost benefit, and then the right advice.
Perfect.
So
That makes sense. So, Kashmira, maybe it makes sense. It's a very valid thought. Maybe having a conversation, understanding the cost benefit of this decision, and then taking the right call might be helpful. Shubha has one question. This is the last question we're taking. For financial assets with no nominations and there is more than one class one beneficiary, how will the transfer happen? Okay.
So if you
Financial
write a will,
assets
you
with
can
no
give it to,
nominations.
yeah, if you write your will, you can give it to whomever you want among the class one beneficiaries. So
Yeah.
you give it equally to all of them.
Okay.
Or if you don't write your will, yes, it will go through to all of them equally.
Equal. But
Nomination,
there's no nomination also.
yeah, that's
That's
fine. That doesn't matter. It will go to all of them equally. Or if you want to give an uneven distribution, then better to write your will.
Okay. So Shubha, class one heirs are the if it's a male, I think it's the mother, the spouse, and the children in equal thing, right? And even if there's no nomination, if one of the heirs make a request and then there is a succession certificate and all of those documents that have to be submitted, then the transfer happens. Is that understanding right?
Yeah, yeah.
yeah.
Okay, okay. So I hope that answers your question, Shubha. So I think we've covered almost all the questions here, and the audience have been very vocal with the questions that they have. So I would like to, for people who don't know us, House of Alpha, in House of Alpha, Harish and I, we are SEBI registered investment advisors. We help people prepare a comprehensive financial plan. We help them make sensible money decisions, make investments that are in alignment with their life and their requirements, and help them execute the plan. And one important part of the financial planning process to have a sound basis and foundation for your financial life is having a sound investment in succession plan. And be happy to have partnered with Plan My Estate, Ravi and Shailendra, who've been helping our clients. I would want more of our clients to use these services. As of now, it's not mandatory, but I would we very quickly want to make this like all our clients must have a will written. We don't want these the family to ever go through this kind of trouble, all of this working hard and investing and putting this money together, and spending so much time and effort in building this wealth is for the beneficiaries, is for their well-being. And if this small little piece is going to create pain, I don't think it's worth giving it to the children. So thank you very, very much for joining the session, Ravi, Shailendra, and all our wonderful guests. We almost had 60 people in the call today. Some of them did, when their questions got answered, they left, which is fair enough. So we have recorded this session as well, so we can be sharing it with the rest of the clients who couldn't make it as well. So thank you very, very much, Ravi and Shailendra. Really appreciate your time.
Thanks, Donna. Thanks for arranging this wonderful session, and for all the participants for taking time off on the weekend.
Yes.
And just before we sign up, the one thing that we have been looking at now is to have an online or an offline consultation of an hour for clients for a very nominal fee, where
Okay.
they can sit with us and understand the whole kind of issues and challenges their estate will maybe have, and then we kind of broadly indicate to them what they should do, and
Okay.
kind of give a health check on their estate plan and say, boss, you need a
Perfect.
will, you may defer the will for some time, whatever it is.
Okay.
Give them some kind of a scoring of out of 10. So we are
Okay.
planning something like this for a nominal fee, maybe, and then a lot of
Okay.
clients can take advantage of that rather than jumping into a will straight away. First,
Absolutely. I think that makes a lot of sense, like a succession audit or something like that.
yeah.
For whoever is there still in the call, do you think that'll be useful? Should we organize something on this? Okay, Sudhir says, I'm looking forward to this idea. Murli says yes. Okay, so I think we will have some interest on this, Ravi. We probably float something like a Calendly or something, so where they can book an appointment and whatever is the
Yeah.
pay,
Yeah.
and then book the appointment
Correct.
and get a broad level idea, is this right
Yeah,
answer
just
their
do an
personal
estate
history?
audit and then decide later. You can decide what you want to do.
Yeah,
And
whether should
not
it be
that,
a gift, should it be a
even if you
will?
want to write your will, not that you have to do it to us. You can go and do it to anyone you think, but we can
Yeah,
give
that's
you the
okay. Meaning, let them
framework.
not go around here and there, right? So
Yeah,
get it.
but I leave it to them. I will
Yeah,
not make that and condition precedent to the whole
yeah,
thing.
yeah, of course. Yeah,
They can
yeah, sure.
choose.
Sure, sure. So that's great. That's wonderful. We also made a little small booklet for all those people who've registered for today's session. We will say a thank you and send that booklet out of FAQs on succession planning with Ravi. Saw and vetted it for us. So thank you very much, everyone, for joining, and we look forward to more conversations about this and more execution. Conversations, enough of them have happened. More executions on this, right?
Yeah, we
So
try to make it as easy for people,
yeah,
and they should not get stressed out about estate planning. It's quite
yeah.
straightforward if you understood your objectives, and we have there as a sounding board. So we can tell you exactly what you should do and simplify things.
Fantastic, fantastic. So thank you very, very much, Ravi and Shailendra. Thanks very much, and happy weekend, everyone. And I'll catch you again for another topic.
Thank you
Bye-bye.
so much, Donna.
Thanks
Thank
a
you.
lot.
Bye.
Thanks. Bye bye.